Throughout their lifetimes, constitutional scholars have dedicated themselves to deciphering sections of the U.S. Constitution and its amendments. The Arizona Constitution presents a similar intellectual challenge, sparking considerable debate over its implications. While interpretations may vary, a prevailing consensus suggests that Arizona real estate licensees are barred from acting as facilitators. This conclusion is drawn from the stipulation stating, "for the parties," or agent for one of the parties to a sale. Numerous perspectives have emerged regarding the interpretation of this amendment and specific phrase. However, in adherence to guidance from the Arizona Attorney General, the prevailing belief is that licensees must represent at least one party involved in a transaction. In the mid-1990s, AAR introduced a revised residential purchase contract featuring a crucial decision point on line 3 regarding representation. Agents were given 4 options, representing the buyer, the seller, both parties, or neither. Unfortunately, the committee overseeing this form, perhaps due to a lack of agreement or understanding of Article 26, approved it with these choices. This was during a time when AAR still relied on printed forms, predating the availability of zip forms. Consequently, brokers across the state eagerly ordered these new forms for their agents. Can you imagine filling out all the forms by hand? However, once the form hit the market, the Arizona Attorney General intervened, instructing AAR to cease and desist using the form. The reason was that the 4th choice, neither the buyer nor seller, was deemed in violation of Article 26 of the Arizona Constitution. This unexpected development forced every broker in the state to grapple with the dilemma of either discarding recently acquired forms or finding a way to manually modify each form by crossing out the offending choice on line 3 of all 4 copies of page 1 for every contract form they had purchased. This undertaking was a monumental task, resulting from AAR's misjudgment in assuming the role of facilitators. While other states permit facilitators or transaction coordinators, Arizona maintains a distinct stance. In real estate transactions within the state, irrespective of the property type or compensation source, representation of one or both parties is mandatory. As discussed above, if a licensed agent is involved in a transaction, that agent must represent the seller or buyer or both. They may not just facilitate the transaction. A dual agent cannot share pricing information, reviewed November 2018. Facts: the broker represents the seller. An offer was submitted to the seller wherein the broker would become a dual agent, first offer. The broker has another offer coming in, second offer. The seller instructed the broker to disclose to the second buyer's agent the amount of the first offer. Issue: can the broker disclose to the second buyer's agent the amount of the first offer when she is a dual agent in the first offer? Answer: no. With regard to dual agency, the consent to limited representation, consent, states that the broker cannot represent the interests of one party to the exclusion or detriment of the other party. See consent at lines 9 through 10. Here, if the broker advises the second buyer's agent of the amount of the first offer, it would be to the detriment of the potential buyer who submitted the first offer. Therefore, the broker should not disclose the amount of the first offer. There is talk about having the buyer pay for their buyer's agent compensation. Here are some questions and answers regarding this. How realtors should navigate the new commission landscape. Offers of compensation are still acceptable. This article and frequently asked questions, FAQs, is the second of a 3-part series that will help guide realtors through the evolving commission landscape. In Part 1, compensation is separate from representation. The article stated that there is nothing illegal, unethical, or improper for a listing agent to offer minimal compensation to cooperating buyer's agents in an MLS for any particular property with the seller's informed consent. The article then discussed a buyer agent's legal obligations and options when confronted with such circumstance. Today's article will consider a seller agent's legal obligations and options regarding cooperative compensation offered to buyer's agents. Remember that there is no offer of buyer's agent compensation in MLS anymore. In Arizona, a listing agent can only enforce their right to compensation by having a valid employment agreement with their client. ARA's Revised Statutes 32-2151.02. Pursuant to this statute, real estate employment agreements are subject to the following legal requirements. I. Be written in clear and unambiguous language. Chi. Fully set forth all material terms, including the terms of broker compensation. Chi. Have a definitive duration or expiration date, showing dates of inception and expiration. And IV. Be signed by all parties to the agreement. Therefore, employment agreements spell out all terms of the employment, including the negotiated compensation for the listing agent and any compensation the agent may offer to a cooperating buyer's agent. Article 1. Code of Ethics requires all realtors to treat all parties honestly, and this duty applies when negotiating terms of an employment agreement. An agent representing a seller owes a fiduciary duty to the seller to act in their client's best interest. ARA's Admin, Rule R4-28-1101A, and Article 1, Code of Ethics. However, the fiduciary duty does not require the listing agent to change or renegotiate their employment agreement with the seller. See generally ARA's Admin, Rule R4-28-1101D. Frequently asked questions. Question. What should listing agents advise their seller clients when discussing their employment contract and compensation? Answer. Seller agents should discuss the amount of compensation to be paid by the seller to them, making it clear that the amount of compensation is negotiable. The amount of compensation set forth in the employment agreement should be documented only after a discussion with the seller has taken place and an agreement on compensation has been reached. The seller agent should also discuss the seller's various options for offering compensation to the buyer's agent and why it may be advantageous to do so. Again, listing agents should make it clear that there is no set or established amount of compensation to be offered to the buyer's agent, and it is therefore up to the seller to determine this amount. Question. Does this mean the listing agent is obligated to offer the amount of buyer's agent compensation determined by the seller? Answer. Yes, if the agent accepts the employment of the seller. Compensation is always negotiable and is agreed upon with the consent of the parties. Question. Should a listing agent insist that the seller allow a minimum offer of compensation to a buyer's agent? Answer. In some instances, a listing agent may conclude that they are unable to effectively represent a seller and effectuate a sale of the property without a minimum offer of compensation to the buyer agent. Article 1. Code of Ethics requires all realtors to treat all parties honestly. If the seller's agent honestly believes that this is the case, they are within their rights to decline the employment. Question. Is a seller obligated to allow their agent to offer compensation to a buyer's agent that they feel is unwarranted? Answer. No. Compensation is always negotiable, and this decision belongs to the seller. Question. Can a listing agent offer minimal buyer-agent compensation with the seller's consent? Answer. Yes. Compensation is always negotiable and is agreed upon with the consent of the parties. Question. Is a listing agent obligated to accept employment compensation in an amount that they do not agree to? Answer. No. The 13th Amendment to the U.S. Constitution protects people's right to refuse to work unless the terms of employment are acceptable to them. Question. Can a listing agent request different compensation amounts based on whether the ultimate buyer is represented, unrepresented, or subject to limited representation? Answer. Yes. Compensation is always negotiable and can be variable with the consent of the parties. Question. Can a listing agent request the same compensation amount regardless of whether the ultimate buyer is represented, unrepresented, or subject to limited representation? Answer. Yes. Compensation is always negotiable and agreed upon with the consent of the parties. Best practice would be for the seller's agent to explain to the seller why the same compensation amount would be justified. Question: if I am a listing agent and I'm communicating with an unrepresented buyer, how can I establish that I'm not representing the buyer? Answer: best practice is for the listing agent to clearly communicate to the buyer in writing as soon as practicable that they do not represent the buyer. The listing agent can also use the real estate agency disclosure and election form to have the buyer acknowledge the fact that the agent only represents the seller. In the event that the parties execute an AAR residential resale real estate purchase contract, this fact can also be documented in Section 8R. Finally, the listing agent should continually remind the buyer that they do not represent them and should document all communications stating so. Aaron M. Green, SQR, a licensed Arizona attorney, is the general counsel for the Arizona Association of Realtors, AR. This article is of a general nature and reflects only the opinion of the author at the time it was drafted. It is not intended as definitive legal advice, and you should not act upon it without seeking independent legal counsel.